Folks, if you've been in this business any length of time, you already know the difference between a clean file and a messy one can be the difference between a smooth resolution and a six-figure nightmare. Late last month, a Portland-based property management company agreed to pay $725,000 to settle claims arising out of a 2023 eviction in Vancouver, Washington. Tenant advocates are calling it the largest wrongful eviction settlement in Washington history. The landlord denied liability, but the number still landed with a thud on both sides of the river. I'm going to walk you through what happened, why Washington's rules made the settlement agreement unenforceable, how Oregon law differs in important ways, and, most importantly, what practical steps every Oregon landlord and manager should take right now, so this kind of exposure never lands on your desk. Princeton Property Management managed Evergreen Village Apartments in East Vancouver. In the fall of 2022, they inspected the unit occupied by Kathleen Allen and her daughter Erin Allen. Both women had significant disabilities. Erin had recently undergone a below-the-knee amputation. The company claimed the unit presented severe cleanliness and health and safety problems and issued a 3-day notice to quit for waste or nuisance. An unlawful detainer action followed. The parties, both represented by counsel, entered a CR-2A settlement agreement. The Allens could stay if they paid the back rent by a hard deadline. The agreement also contained language that the parties would forego the usual unlawful detainer procedures. When the rent arrived 1 day late, tied to medical care, Princeton refused the payment, obtained an immediate writ of restitution, and the Allens were removed in April 2023. They experienced prolonged homelessness. Kathleen Allen later passed away. The Washington Court of Appeals, Division 2, issued a published opinion in June 2024, holding the settlement agreement void and unenforceable. Under RCW 59.18.230, subsection 1b. That statute contains a broad anti-waiver rule. Any agreement entered into pursuant to an unlawful detainer action that waives any tenant rights under the Residential Landlord-Tenant Act is void. The court applied the language strictly. A subsequent civil lawsuit alleging wrongful eviction, disability discrimination under state and federal fair housing law, retaliation, and Consumer Protection Act claims settled in June 2026 for $725,000. Washington's statute is unusually explicit. Any agreement, oral or written, made in the middle of an unlawful detainer that waives notice rights, reinstatement rights, repayment plan rights, mediation rights, or the usual unlawful detainer procedures, is dead on arrival, even when both sides have lawyers. Lessons from across the Columbia still apply on the Oregon side of the river. Oregon does not have an identical provision. ORS 90.245 prohibits rental agreement provisions that waive or forgo rights or remedies under Chapter 90 and makes knowing use of those provisions actionable. ORS 90.412 and 90.414 carefully regulate when acceptance of rent does or does not waive a termination notice. And ORS 105.145 expressly authorizes stipulated agreements and judgments in FED cases. Oregon courts routinely enforce properly drafted stipulations that resolve possession and payment issues. That is the good news for Oregon operators. You generally have more flexibility to use carefully drafted stipulated agreements in FED court than a Washington landlord currently does. But more flexibility is not a blank check. You still cannot force a blanket waiver of Chapter 90 rights. Any agreement that is overreaching, poorly documented, or entered under pressure can still be attacked under unconscionability principles under ORS 90.135, retaliation under ORS 90.385, or fair housing theories. The Washington case is simply a vivid illustration of how expensive aggressive enforcement becomes when documentation of conditions, disability accommodations, and settlement language are not airtight. If you own rental property in the Portland Metro or Central Oregon areas, and the thought of navigating a complicated FED stipulation or disability-related accommodation request keeps you up at night, talk to the team at Northwest Real Estate and Property Management, www.nwrpm.com. We handle eviction processing and full management every day, and we do it with the documentation and process discipline this case shows is non-negotiable. And if you want access to landlord forms, continuing education, and a network of owners who have already learned these lessons the hard way, join PAROA at www.paroa.org. Membership pays for itself the first time you avoid a six-figure headache. Okay, back to the meat of it. Even though the statutory anti-waiver rule is different, 4 practical failures that showed up in the Princeton file can still produce serious exposure in Oregon. First, inadequate photo and video documentation of unit condition at the time of the notice and throughout the process. Second, failure to engage in the interactive process when disabilities are known or raised. Third, overbroad settlement language that tries to shut down every procedural protection. And fourth, aggressive enforcement of a technical deadline without considering whether a court or a jury will later view the one-day delay as de minimis in light of medical issues. Fair housing claims are especially expensive. Disability is a protected class under both federal law and Oregon law. Once a disability is known, the interactive process is not optional. Class materials and transcripts we use in our education programs hammer this point repeatedly. Document the request, document your response, document the reasons for any denial, and never treat a disability-related request as just another rule violation conversation. Helpline data over the last several years shows that calls about eviction, fair housing, reasonable accommodations, record-keeping, and settlement language remain among the most frequent topics members raise. That frequency is not a coincidence. These are the areas where the financial risk is highest. Thorough photo and video documentation at every step remains the single best defense against later challenges. Here is the practical list I want every Oregon landlord and manager to keep handy. Photograph and video the unit thoroughly at the time of any notice for cause and again before any settlement discussions. Timestamp everything. If disabilities are known or raised, open a written interactive process file immediately. Use a formal request form. Send verification requests when appropriate and keep every communication. When drafting or reviewing a stipulated agreement under ORS 105.145, keep performance deadlines realistic. Build in a short cure period for payment if medical or other legitimate issues are on the table. Explicitly state that the agreement resolves only the possession and payment issues described and does not waive any other rights under Chapter 90. Oregon allows more flexibility than Washington, but overreaching language still invites attack. Have high-risk agreements reviewed by counsel experienced in Oregon landlord-tenant work. The cost of a one-hour review is trivial compared with a six-figure settlement. Never treat a one-day late payment as an automatic green light for immediate enforcement when disability or medical issues are documented. Courts notice that kind of aggression. And keep the entire file. Notices, photos, emails, settlement drafts, payment records, organized so that if the matter is later challenged, you can hand the complete story to your attorney in one clean package. Oregon's attorney fee and damages landscape is different from Washington's, and the $725,000 figure is not an Oregon verdict. Still, the case shows how quickly costs escalate when the file is not clean. A successful fair housing claim, a retaliation claim, or an unconscionability challenge can produce actual damages, statutory damages, emotional distress damages, and attorney fees that add up fast. If you manage on both sides of the Columbia, treat Washington's anti-waiver rule as a hard constraint and Oregon's greater flexibility as a privilege that still requires discipline. Thorough move-in and ongoing inspection photos and videos, written interactive process records on disabilities, and settlement language that is realistic rather than overreaching remain the best insurance policy available in either state. The $725,000 settlement is a cautionary tale, not a prediction of what will happen in every Oregon case. But it is a very expensive reminder that process and documentation are not optional. Get them right, and you stay in the business of owning and managing rental housing. Get them wrong, and you may find yourself writing a very large check instead. What about you? Have you ever had a settlement agreement or a disability accommodation request go sideways? Or do you have a documentation tip that has saved you? Drop it in the comments so we can all learn from each other. Hey, if you're a Portland area landlord, come join the community over at www.paroa.org. We've got education, forms, networking, and we fight for your rights at the legislature. And for owners in the Portland Metro or Central Oregon looking for hassle-free management, check out the pros at www.nwrpm.com.